Anybody can call us. We'll take a phone call from anybody about any family member, friend, whatever it might be, and are happy to talk with that person to the extent they've been given permission to talk with us. When it comes to actually retaining our office, a parent can retain us on behalf of a minor. Someone with power of attorney can retain us on behalf of whoever they have power of attorney for. Or if none of those exist, then the person who's been injured needs to be the one that actually signs the retainer agreement that makes us their lawyers. And in the case of a wrongful death, the state of Minnesota requires that a representative, we call it a trustee, is appointed on behalf of the estate to pursue any sort of action. The person appointed can be a family member, oftentimes is, and oftentimes we assist in that process. The only caveat is that every other next of kin who survives needs to agree or acknowledge that they are okay with that person being appointed. And then that trustee, once appointed, which requires judicial approval, is allowed to and can sign a retainer on behalf of the person who has deceased and their estate. If the person is compromised and can't make decisions on their own behalf, you can have what's called a guardian ad litem appointed, which is similar to a trustee in the case of a wrongful death. And that person who is appointed is given the ability and the legal authority to enter into legal contracts and agreements on behalf of whoever they've been appointed to represent.